Right. Good afternoon, everybody. Thank you for joining us. We're just starting a couple of minutes late, as I could see that the attendees and were ticking over. So thank you for your patience. Welcome to the latest Local Family Justice Board webinar. We're delighted that you're able to join us. You would have seen from your invite that the title and the topic today is Special Guardianship Orders and their support plans, key insights and expectations. It should be, we hope, of assistance both to the lawyers who attend the family court and also to the social work practitioners. Our programme today is as follows. Starting us off is Louise Ballantyne, a barrister at Fenners Chambers, and she will help us with an overview of special guardianship orders and support plans, the regulations about those from the legal perspective. We then have a joint presentation commenced with Steve Crossman and Ana Caldararu of Cambridgeshire County Council and Stuart Stapleton and Sue King from Peterborough City Council, who together will discuss the support that their teams provide and how these plans are drawn up. Our third speaker is Nicola Silk, a consultant CAFCASS advisor, family court advisor, and she will assist from a CAFCASS perspective as to the key expectations that they have for a plan and the information that they need to approve special guardianship plans. And lastly, our designated family judge for Cambridgeshire, Her Honour Judge Gordon Saker, will speak about the court's expectations for a tailored special guardianship plan. If we do have time at the end, we can try and field some questions, and there is a function in Zoom to be able to ask questions. And if we have time, we will try and get through some of those towards the end. So that is our plan for today. And if I may hand over to Louise, our first speaker, to commence the webinar.
Good afternoon. I'm just going to go and try and do the technical bit to start, just to share my screen. There we go. So yes, good afternoon. As Lisa said, I'm looking at just a brief overview of the Special Guardianship Order regulations, a lot of which we may well recognise in practice, but we won't necessarily know all the ins and outs of where they come from. I won't go through all of the regulations step by step, but I'm just having a look at them on a somewhat of a broad brush approach, but also picking out some of the parts that I think are most relevant to us all within our practice. So just the easy bit to begin with, where they can be found. I'm not sure actually whether my slides are going to be circulated, but there is a hyperlink if needs be, but they can easily be accessed. And what we're looking at is the 2005 regulations as updated in 2016. In terms of what they cover, a majority of it really is looking at support, both practical support and financial support, as well as reviewing those and how they can be challenged and what they should be including and what, on a more basic level, it is meant by support. So just jumping into the first bit, looking at Regulation 3, this actually, from my point of view, was quite interesting when I was reading it, because we, as I've said, we often deal with these things on the ground, but don't necessarily go back and constantly refer to what the regulations say. But in terms of support, it's required under Section 14F of the Children Act that the local authority consider what support should be offered, and that sets out counselling advice and information, but also other services as are prescribed. And it's Regulation 3 that tells us what it's envisaged that support could or should include. Now, the obvious one is financial, and of course that's often where our minds go if we're representing prospective special guardians, to look at the financial support to ensure that that's in place, and I will go into more detail on that slightly later. The other matters that the regulations say that support can include is services relevant to the specified people, and they're the children's special guardians or prospective special guardians or parents. And it's to enable them to discuss matters relating to the special guardianship, assistance including mediation around contact, therapeutic support for the child, and support in continuing the relationship between the special guardians and the child, including training and mediation. And again, I think it's helpful sometimes if you're looking at a plan just to refer back to that, because as I'm sure may well be said later on, that there are some plans that sometimes cover the generic, but really what the way I interpreted is that this level of support is to go beyond the generic, and really is to go into the areas that the special guardians need assistance because of the child that we're looking at, rather than, as I say, just generic support. Moving on from that, just to touch base, again, it's a matter we sometimes are faced with in terms of looking at support, and that's provision of services for persons outside of the area. And this really is looking at the situation where the child is in the care of the local authority immediately prior to the making of the order, but of course maybe being placed out of the area. And the general provision is that provision of services shall apply for 3 years unless there was already financial support, as in under these regulations that was in place prior to the making of the order. That's not talking about other forms of finances in terms of foster payments or anything like that, which again I'll touch on later, but it's talking about the somewhat rare situation if a financial provision under special guardianship support was already in place. And again, I think that's something that we're not likely to come across very often. In terms of moving on to, as I say, perhaps the most known topic when we're looking at support, which is financial assistance, it's very broad in terms of the provisions that the local authority should be considering when looking at financial assistance. And again, it uses terminology such as when the local authority consider it necessary, and when the local authority consider it appropriate. So just looking at the specifics there, it's the local authority that she have to consider if they financial support to be payable when they consider it necessary to ensure that the special guardian can meet the care needs of the child. And then you have more specific examples in terms of if the special care needs require a greater expenditure of resources than would otherwise be the case. But again, that's very broad, because when looking at special care needs, it says that they can come because of illness, disability, emotional, behavioural difficulties, or the consequences of the child's past abuse or neglect. So that's a very wide category that can be used when considering what financial support is needed. There is the known one in terms of when the local authority consider it appropriate to contribute to legal costs, and as we know, that's often the case where they're proposing that a special guardianship order is made, and a provision of legal advice is given to the proposed special guardians, in particular to look at the ins and outs of the plan and financial support that's being offered. And then again, the last one that we would have all come across is if the local authority consider it appropriate to contribute to expenditure necessary for the purposes of accommodating and maintaining the child. And I'm sure we've all over the years had cases where it's been suggested we build extensions, or the local authority build extensions and whatnot. But it comes back to appropriateness and necessity. And as much as some may argue, a conservatory is necessary, it falls on the facts of the case, as I'm sure we all know. I mentioned earlier, just briefly, in terms of when there's already been financial support in place, the provision of financial support under the plan shouldn't ordinarily be a form of remuneration. But in the circumstances where the special guardians have been foster carers, again immediately prior to the making of the order, it can, if agreed, again if seen as necessary, include an element of that. And the general provision is that would be for 2 years, but it's open for the local authority to agree longer. Again, we've often had recommendations of requesting the local authority to consider providing foster care allowance level payments until the child's 18, but it's very much in the discretion of the local authority in considering what they feel is necessary, or based on the facts of each case. A matter to consider when advising proposed special guardians, for those of us that do that, is that there are within Regulation 10 just some conditions that the special guardians are in effect signing up to. And it may not be necessarily clear, but it's just something to be mindful of when, as I say, when looking at special guardians and the plan that they're being asked to sign up to, is that it's suggested within Regulation 10 that they have to agree to update the local authority as to their changes of their address, their financial circumstances, and any other matters really that would be considered relevant to the provision of support. And that's something just to bear in mind, that special guardians are aware of that when they are, as I say, signing up to these plans and caring for the children that we propose placing with them. In terms of financial support, again, relatively straightforward and something we're all familiar with, but it just sets out there in detail as to what should be taken into account when the assessment for financial support is being undertaken. And it includes such matters of the developmental needs of the child, the capacity of the guardian, the environmental factors, and the local authority have to consider within that the needs of the people that they are assessing, the special guardians, as well as the need of the child. So it's really a broad set of circumstances that have to be considered when looking at that financial support. And then again, the one of the matters that I know Her Honour Judge Gordon Saker is going to speak about, I believe, is that of the plan. And I was surprised when I looked at the regulations that there really isn't much guidance within those regulations as to what that plan should set out, other than what the support is. It does set out about that if the local authority are saying that there's a need for services from the local health board, the integrated health board, or the NHS, or another local authority, that those people should be consulted before the plan is put together. But in terms of really being clear as to what the plan should set out, the regulations don't really assist on that. But in practice, of course, it is making clear, and perhaps referring back, as I said, to in terms of Regulation 3, the support that's envisaged that a plan should include as in above and beyond the generic. It's really setting that out in detail and how that is going to be provided and reviewed, rather than just setting out what sort of day-to-day practices. But yes, if you're looking for somewhat of a crib sheet for the plan, then unfortunately Regulation 14 isn't the one for you, because there isn't very much in there at all to assist with that. I've done two different slides, but I'll deal with Regulation 15 and 16 together, because what that looks at is that when a local authority prepares a plan, that's how that should be served upon the proposed special guardians. And it specifically references within the regulations that there should be a set time frame for representations to be made by the proposed special guardians as to whether or not they agree to the support that's being provided. And both of those provisions set out the information that the notices of that support should include. In respect of general support services, not financial, I'll come to that in a minute, because there's some additional ones in respect of that. But it says that the notice must contain a statement as to the person's needs for special guardian support services, where the assessment relates to his needs for financial support, the basis upon which that support is determined, whether the local authority to provide him with special guardianship support services, the services that are proposed to be provided, if financial support is to be paid, the proposed amount, and any conditions, as I said before, that come under Regulation 10. And then in respect of finances, again, it just sets out more specific information in terms of the frequency and period of payment that should be set out. So it's important just to be sure that all that information it is being provided, and also that the time frame in terms of how long the person has to respond and confirm whether or not they agree to the proposed support, and whether there's any further requests for the support for the local authority to consider that. And also it should go without saying, but no decision as to the final plan should be made until that time to challenge has been passed. And as I say, that's set out in 15 and 16 separately in terms of general support and financial support. But the principle is the same in respect of both. Following on from that, when you look at Regulation 17, that just gives some helpful general provisions, and it looks at the review of the support services that are being offered, and it also makes clear that if the local authority are proposing that there should be any changes to the support given, then the Regulation 15 and 16(3) that I've just been through in terms of how that notice should be given and time for that to be reconsidered are applicable as well in terms of the initial support plan or any changes that the local authority propose to make. And in respect of financial review, that again is something that is expected to be reviewed annually. One of the conditions usually put on is that the special guardians provide an annual statement as to their financial circumstances, but also it's provided in there that the local authority can review that after any changes of circumstances, or at any time the local authority consider it appropriate to do so. So that's somewhat of a whistle-stop tour as to what the regulations say. As I said at the beginning, a lot of it we all do in practice in any event, but we're not necessarily familiar as to exactly where each provision sits within those regulations. As Elisa said, if there's any questions, just put them in the chat box, and if we've got time at the end, and if I know the answer, we will answer them. But if I don't know the answer, then we definitely won't have time to do so. But I'm just going to pass over now to Steve Crossman, who I believe is going to talk about more support offered from a more practical point of view. Thank you.
Thank you, Louise. My name is Steve Crossman, and I'm joined today by Ana Caldararu from Cambridgeshire, Stuart Stapleton and Sue King from Peterborough, and it's my pleasure to be part of the LFJB workshop today. I'm just going to fiddle with the technology in the hope that I will be able to share the practice approach, which is very similar within Cambridgeshire and Peterborough, for how we both assess and support our special guardians and how we apply those regulations to what we do. Now, I'm sure you can appreciate that supporting special guardians and assessing special guardians and connected persons is something that could be spoken about for many hours. However, I will provide the most condensed version that I can this afternoon. I think it's important that that we acknowledge the national context of kinship care within the UK at the moment, with around about 132,000 children understood to be living within kinship care. And there is a huge increase in the interest and action on behalf of the government around connected persons and kinship care, which is recently acknowledged as well within the Kinship Statutory Guidance, which was published in October 2024. Alongside that guidance, the Department for Education has also published a number of research papers, almost starting in 2014 with the Wade et al. Paper upon special guardianship, which has really given a vehicle for which the needs of the kinship carer population have been put on on a better level. It is well acknowledged within research recently published by the Kinship Charity that 73% of applicants tend to be grandparents, with 13 other close family members, and the remainder family and friends. I think it's also important to note, because it gives context to this presentation, that kinship carers are recognised to have statistically lower levels of emotional well-being, higher levels of isolation, and acknowledge that they are often not well supported by the local authorities that serve them. And local authorities across the country, under the leadership of the new kinship ambassador, have been given a strong mandate to improve the connected persons assessments and the services that are provided to them and their families. Within Cambridgeshire, there has been a great deal of movement within the last year. We were proud to be part of the Department for Education's programme through an organisation called Practice Guides to develop our connected persons local offer and the support provided to kinship carers. But what we have also seen is a huge increase in how we are identifying connected persons carers at the earliest point. So for those of you in this webinar, you may be aware of something called Regulation 24, the Care Planning and Placement Regulations, which enables local authorities to identify people that may be safe to care for a child in the event that their parents are not able to do so, to undertake a viability assessment and to approve them as, in effect, emergency foster carers whilst a full assessment is being completed. Cambridgeshire has seen quite a significant increase in the numbers of Regulation 24 carers, represented at being around about 68% in the last year, and a 23% increase in new kinship carers. This is actually quite positive, because what we are saying is that we are working hard to identify the persons that are most important to that child, to avoid them being cared for by effectively stranger foster carers. We have also seen, as a result of the increase in Regulation 24 carers, a 100% increase in the number of fully approved kinship carers. Now, whilst that is an encouraging statistic, what we are also wanting to make sure as a local authority is that children are not languishing within the care system under Regulation 27, but are also, where it is right and appropriate, supported to exit the care system onto a special guardianship order with good support. Also, I think it's helpful to share within Cambridgeshire, we have noticed a considerable increase in requests for enhanced payments. Louise shared earlier within her presentation that the local authority is given a duty to consider what payments and supports are necessary in order to help a child to thrive. We do have a very clear family and friends policy that is published on the Cambridgeshire County Council website that is consistently open for consultation. But what we know is that whilst we have a universal offer to kinship carers, we are often met with requests for extended financial periods for conservatories, cars, and enhanced payments in order that carer may be able to meet the child's needs in the long term. Whilst it was acknowledged that the regulations do not necessarily give a specificity to how the support plan is going to be collated, we do use what is referred to as the Form K. The Form K was put together by BAF Quorum as along with other representatives. So it was put together in partnership with the judiciary, with kinship carers and other organisations to make sure it represents what support the local authority is going to provide to the children and their families in the long term. So it provides a good framework, I believe, in order for us to articulate what that support will look like and how to consult with carers and develop that support plan, which I will talk about shortly. We are and have been required under the statutory guidance for kinship carers that was published in October 2024. We have published our local offer, which is available on the kinship website, which contains lots of information, including how to get support, what that support would look like, how to get training, the counselling, the financial support, and other community level support. We encourage any barrister and solicitor who works with special guardians to consistently recommend that their clients access the local offer because it is explicit as to what support may be provided. I'm going to hand over now to Stuart to talk about Peterborough.
Hi, thank you, Steve. So in Peterborough, we've seen some of the similar trends, obviously a very different geography to Peterborough City than Cambridgeshire, but what we have seen is an increase in our connected persons approvals through fostering. So I mean, 3 years there is almost a 100% increase each year. That doesn't mean they remain as connected persons foster carers. Many do then achieve special guardianship orders, but what we are seeing is the use of Regulation 24 more often, and those going to full assessment. So we have a dedicated kinship team which has got 6 social workers, and in terms of statistics for last year, there were 93 referrals for kinship assessments, and by year end we had 25 connected carer households. That now, and we're in Q3 now, but that's, we're down to 15, which would suggest, there'll be many that have gone to obtain special guardianship orders. But last year we were able, we had 28 children who achieved permanency through special guardianship orders. So I'm going to pass to my colleague Sue now.
Good afternoon, everybody. I'm Sue King, one of the service managers in Peterborough. Nice to meet you all. So I'm going to speak a little bit more about the local context in Peterborough. For those of you that are more familiar, there is a really well-established and active local kinship support group. So in some ways, it's kind of easier for us to get the views of those experts by experience, and develop that relationship and include them. And I think what we've seen most recently is, I think on the back of the situation that Steve described in terms of national initiatives, that actually they are becoming much more involved in helping us to develop our policies. So for the first time, we have a kinship foster carer on our corporate parenting board. And they have representatives as well who are part of the National Kinship Care Ambassador Board. So it does feel that Peterborough and the local area are their voices are increasingly being heard. I mean, the kind of things that they're saying to us, they have been saying to us for a long time, and I guess it does feel like we're being given the opportunity to listen more and to include them more, and that there's that drive really to kind of really include them. So Tasla Cheyenne is our team manager in the kinship team, and you may have heard her name, and she's working with them very closely to develop our local offer and co-design that with the local kinship group and other partners. And yeah, you know, I suppose it is important to recognise that our the lead member for Children's Services and our directors you know, are very keen that we do what we can to support kinship carers, recognising the importance of keeping children within their kinship settings. Thank you.
Thank you, Sue.
Welcome.
I want to start off with an acknowledgement before I share this very condensed version as to how a support plan may be arrived at. And you will acknowledge there are several omissions from here immediately from Louise's presentation. The purpose of the kinship assessment, whilst it is an assessment to understand how a child may be supported within a home with which they're connected to, and makes recommendations as to which outcome is most appropriate for that child. The culture within the kinship teams within both Cambridgeshire and Peterborough is to both assess and equip. So supporting that kinship family starts on day one. We need carers to be well advised, to be trauma informed, to be well supported both now and to meet the child's needs in the future. So through the assessment, the social worker and the applicant will articulate what support is required now and in the long term. Does that carer need specific training? Do they need specific equipment in order to care for the child? Arrangements? How are they going to support the child in having an effective relationship with the people that are also very important to them, such as their birth family? Those are considered from day one, almost from the viability assessment stage, and through the intervention, we will be considering how it is that we're able to provide those services. As was referred to earlier, the financial support that connected persons will receive is clearly very important to them and enables them to sustain the children within their care. Within Cambridgeshire, we use the Department for Education's financial means test, and we publish very clearly within our policies that we, in effect, provide financial support for the first year and for 2 years when they are kinship foster carers. However, we do acknowledge the right of the special guardian to seek additional financial support through requesting a means test on an annual basis. We do want to support our special guardians with good financial support, and we align that to level 1 of the fostering allowance that's provided within both Cambridgeshire and Peterborough, which is published as well on the websites. The Department for Education financial means test takes into account relevant benefits and incomes that are provided to that family when coming out with a final number, and that we want that number to be provided to the applicants at the earliest point in order that they can make representations on the support that they're going to be receiving. As I acknowledged, in order to make sure that children have really good, stable homes, both in the immediacy and in the long term, we work with the special guardian, the child social worker, and the special guardianship assessor to articulate what we believe those support needs are going to be. The participation of the connected person's carer is incredibly important, and we want to do that in partnership with them. It does, of course, include all practical support, therapeutic support, financial support, and this is articulated within the form that I referred to earlier, called the Form K, that is sent to the court. Now, and to parties for representation, of course. On occasion, as I referred to, there are requests for exceptional allowances, and these do require additional considerations. In Cambridgeshire County Council, what happens is there is an enhanced payment form which is sent to myself as the head of service and discussed with the director as to whether or not we are able to meet the requests from the individual guardian. We do give each application due consideration as to whether or not it's both necessary and proportionate and available for the local authority to provide, and that the answer to that is then provided to that applicant. In Peterborough City Council, this is considered at the exceptional circumstances panel before being sent to a service director for consideration. So there is, as you can read, quite a lot of scrutiny. The assessment of what support is provided and the consultation with the carer are then provided back to the applicant within the special guardianship support plan. For those of you that have seen a Form K, you will acknowledge that at the very bottom of that support plan is a request for the signature of the applicant to make sure that they have had the opportunity to be consulted with about the support provided to them prior to it going to the court and relevant parties. I have spoken a little bit about the support that's available to relevant parties, relevant applicants, to include financial support, as I defined earlier, It may also include housing, which can include adaptations or support requests to housing authorities. It may involve mediation and being able to work effectively with the wider birth family. It may include support for family time, which is another word for supervised contact, to ensure that that child is able to have both a safe and positive experience. Within Cambridgeshire, for example, any training that is available to foster carers is made available to connected persons. We've spoken a great deal about special guardians in this presentation and the special guardianship regulations, but what we are very much trying to do is adhere to the culture that is requested by the National Kinship Ambassador and treat our informal kinship carers, our carers with a child arrangement order, our special guardians and our kinship foster carers and private foster carers with the same levels of service. What that also means when we think about the referrals to the Adoption and Support Fund is that back several years ago, if you were a special guardian seeking support, you would need to wait for the outcome of an assessment for to the Adoption and Special Guardianship Support Fund to find out what you may be eligible for. Now we make sure that any special guardian or connected persons carer that seeks support is eligible for universal services also, so that they get the best support in the quickest amount of time. Whilst Peterborough is quite privileged to have a very well established support group, Cambridgeshire is currently developing theirs across the county and is using the Kinship Week to really bolster its efforts. But what we want is for good community support for connected persons and kinship carers to be available at a local level. And of course, as is visible on the local offer website, there is a great deal of support available from the virtual schools as well, in both articulating what the child's educational needs might be and providing representation to the local schools as they meet the needs of their students. I do apologise, there's just one more slide that has gone awry because the technology never works all the way through. As local authorities, we do acknowledge some key challenges at the moment. The first of those being resource constraints. Whilst the government in its Pathfinder programme has set up some local authorities to provide a universal allowance, I believe this covers 13 authorities at this time. That is not the case with either Cambridgeshire or Peterborough. And at the moment, we are not receiving central government funding in order to provide a universal allowance to kinship carers. And we do hope for central government advances on this. We are aware of critique from the court and parties that at times our SGO support plans are too generic or too lengthy and need to be more articulate. And this is something that we are wanting very much to work towards. We do acknowledge there is an increased level of need, an increased level of requests for enhanced financial support, as well as support that extends beyond the order. Many years ago, it may have been a culture that when you became a special guardian, you went off into the distance. The culture that we want as local authorities is to continue to provide close support to help people feel connected. And before things become too difficult, for them to know that they can rely on the local authority for the support their families need. It is tricky in terms of court timelines, as you will all be aware. The need to go through somebody's personal history, the journey that they go on as they often suffer grief within their family and shock is a considerable one. And the need for a minimum of a 12-week assessment has never been more significant. Often people require additional time to understand whether they can commit to that child for the fullness of their minority. I'm going to stop sharing my screen now and pass back to the presenter. Thank you very much, everybody.
Thank you, Steve, and your colleagues. The next speaker is Nicola Silk, please.
Thank you. Good evening, everybody. I'm going to try and share my screen now and hope that it works. Just bear with me. There we go. So, oh, it's gone on too quick. Just bear with me a second and I'll start it again. And it's still going on too quick. Bear with me. It is not playing at all. There we go. Lisa, am I sharing my screen now?
I can't see it at the minute, Nicola, no.
Okay, I'm having a bit of a mare. Just bear with me.
Yeah, no problem. Thank you.
For some reason, it is not letting me share it. We did practice this, I promise all of you, and it did work. Right, have we got it now?
We have, Nicola, yes.
Great, thank you. And it is at the beginning, according to my screen as well, which is a good start now. So I'm Nicola Silk, I'm Consultant Family Court Advisor with CAFCASS, and I'm based within the Cambridgeshire team. So I generally cover any applications made by Cambridgeshire County Council. So I'm going to talk about what CAFCASS needs to see to approve a plan of special guardianship and what we expect to see from the contents of the support plan. So we are guided in our work by practice quality standards, and CAFCASS have practice quality standards in both public and private law. These are quite lengthy documents that we use, and they talk about different aspects of our work. The practice quality standards for public law are based on our best work and set out, oh, it's gone forward again, and set out what is expected in response to learning from feedback, audit, case reviews, and to fulfill our commitment to contribute to a whole system effort to implement the recommendations of the Public Law Working Group. The practice quality standards guide practitioners in different aspects of practice, and they set out what good looks like, what children and families have a right to expect of us, and what our family justice partners can expect of us as well. Now, in terms of the public law practice quality standards, it's practice quality standard 6 that provides guidance on what children's guardians should be looking for when considering a special guardianship. So practice quality standard is specifically to provide guidance, and there are 8 things that we need to consider. They are quite broad in some respects, but specific in others. And these are available. I'm not going to go through each of the 8 points because they are available on CAFCASS's website. You can see the whole of the practice quality standards on the CAFCASS website. What I will do instead is explain what it means in practice. So in practice, it means that the children's guardian has to scrutinise the assessment. This ensures it's a robust assessment that considers not only the prospective special guardianship's ability to care for the children, but also their understanding of the circumstances of why they are caring for the child, an analysis of their ability to care for each of the children, given their specific care needs throughout their childhood. So we start by looking at the assessment. We then have to look at the support plan and feel confident that any support needs and vulnerabilities identified in the assessment are addressed in the support plan. As part of our work, we have to have sight of the DBS and medical checks of the proposed special guardians, and this can either be via the social worker, or often we ask the prospective special guardians during a visit to see a copy of their DBS and a copy of their medical checks. Without seeing these for ourselves, we can't endorse or recommend a special guardianship order in our final analysis. This isn't that we don't trust that these checks haven't been done, it's just double checking that they have and making sure that we are satisfied ourselves that there's nothing on these checks that need further consideration. We need to be sure that there's been an appropriate testing period of the placement, and we often do that within proceedings. We often have the assessment and then consider a move to the carer if the children aren't already placed there at an initial viability stage. And that's so that we can go and visit, we can complete observations of the children in the prospective special guardian care, we can see where they're going to be living, we can have conversations with the special guardian and the child about that, that living arrangement, and just satisfy ourselves that it is the best place for that child or children. It also means ensuring that the special guardians have seen their assessment and support plan. And again, we do this through visits and through discussions to the prospective special guardians. They need to have had the opportunity to discuss the assessment and the support plan with their social worker and with the child's social worker, and had access to their own independent legal advice. We'll talk to the special guardians about if there's any support needs that they feel have not been included within the support plan. We will liaise with the IRO to be satisfied that they've seen the support plan and are content with it. And again, they might have ideas about things that may have been missed or overlooked, or things that need to be just further considered within that plan. It means that we have to thoroughly consider the support plan to be satisfied it's personalised to that child's specific needs, and that it's not generic, and that the financial offer is in line with regulations. In practice, this could mean ensuring that specialist therapeutic support is in place or agreed, additional financial support over and above that of the standard offer, commitment to continuing supervision of family time arrangements, or risk assessments if a parent's situation changes, for example, upon release from prison. These are examples of just some of the things that we may consider through the support plan and for each of the children. So in summary, in order for a children's guardian to approve the plan and be confident in the support plan, we need to know that the plan is robust, is personalised, it recognises any vulnerabilities of the proposed special guardian, and it considers the needs of the children now and throughout their childhood and adolescence. So I've included a couple of useful links, and hopefully they can be shared if the slides are going to be shared, or you can look online for the public law quality standards. That's on the CAFCASS website, and there's also a link within them to the President's Public Law Working Group report, which is where our practice quality standards have been devised from. I'm now going to hand over to Her Honour Judge Gordon Saker, who's going to talk about the court's expectations for the plan and the assessment.
Thank you very much. Can I first of all, on behalf of all of us, thank all of our speakers, because between you all, you've put together very helpful information on the outline of the regulations, then the details of what should be in a plan, and also CAFCASS's expectations. And I think that's really helpful for everybody attending today. And can I also, on behalf of all of us, thank Lisa and Sally Gore as well for arranging today, because a lot of work goes into organising this. And of course, for the speakers, a lot of work goes into putting together their presentations. And I think we're very fortunate with these webinars, which take place a few times a year. I'm apparently going to tell you what the court expects. And those of you who appear in front of me probably know what my usual moans are. I see special guardian support plans, obviously, quite often. They're often about 20 pages. There are columns and boxes filled in on the form. And most of the time, the financial arrangements are not the problem. Occasionally, there's a specific difficulty which needs to be addressed, such as extra housing. Sometimes it's a car. If somebody's going to take on 2 or 3 children and they've got a very small car, they need help there. But I don't often see a problem with that. I'm afraid where I tend to see a lack of detail in the plan is on the practical support. The plans will say in one column, the child needs a doctor, the child needs a dentist, and then it says the special guardian will find a doctor, find a dentist, which is obviously relatively straightforward, and that's what we would expect. The problem, from my point of view, comes when a child needs therapeutic support, extra help with educational support, or the family needs help with contact. Because almost by definition, in a case where we are making a special guardianship order, the child has suffered significant harm, and therefore their needs going forward are greater than a child who hasn't suffered significant harm. And I was particularly interested in the local offer which Steve went through, and also the part Nicola went through of expectations, because the plans always have the local offer in the boxes, but regrettably, in the box about the support that's going to be provided, it quite often says the special guardian can access this website, the special guardian can talk to the virtual school, the special guardian can look for training courses online. And I'm afraid that's where I say that's not what I expect. What I need in a plan for a child is the specific details for this particular child. If you've paid a psychologist to give you an assessment and tell you that your child needs this, that, or the other therapy, then what needs to be done is that therapy needs to be provided. If we are told that contact needs to be supervised, saying that the special guardian must find a relative to supervise it, to my mind, I'm afraid is not support. So what I want to see in a special guardianship support plan, and to be fair, I am seeing that more. I had one today, for example, where there was a lot of tailored support in the plan. But what we really need to see is actual detailed support, not references to website, not telling a special guardian that they can go and look for it, or they can apply for it in due course. I know, we all know, that local authorities are not bottomless pits and have finite resources. But actually, if you spend the money now on getting the child the therapy, if you spend the money now on supporting the child to get into education, on supporting the contact arrangements, you probably won't find yourself back in further care proceedings in 2 or 3 years' time, or worse still, in deprivation of liberty proceedings 5 or 6 years down the line. And so, to my mind, it's not just about the financial cost now, it's about the children's welfare going forward and preventing the financial and emotional cost of not providing the support. So I think these presentations have been excellent, but what I really need is on the ground to see that the detail is in the plan, so that we're not sitting there having hearings, as it were, arguing about it, and then having to adjourn a case to come back a few weeks later with a plan with more detail in. So that's my one plea, as it were, on behalf of myself and my colleagues, and indeed, most importantly, on behalf of the children, that the plans do have the detail and are not generic and are not vague. But having said that, I think we all know that that's the plan and everybody's working towards that end. I just hope we can get closer to it in every single case. Thank you.
Thank you, Judge. And thank you, everybody, for your helpful presentations and the detail that was provided. I don't think actually we have any questions in the chat box or the question and answer box. So I don't know if anybody watching wishes to type anything in the chat box or the question and answer box. We can hang on for a few more minutes if anybody wishes to type a question. But otherwise, that would then conclude our webinar. So I'll hang on for a couple of minutes in case there are any questions. There is one question in the Q&A box. It says if anyone might be able to share a really good example of a plan. I don't know that we can without lots of redactions. I don't know if that is possible off the top of my head. in terms of confidentiality. I don't know if anybody else has any thoughts on that. That was just me thinking out loud, whether that would be possible. Louise, do you have any thoughts about that? Oh, I see Steve has his hand up actually. Was that in reply? Oh, Louise is coming through.
While Louise's technology is working, I'll happily answer that. I think it would be really helpful within the local offer website for Cambridgeshire to have a good example of a fabricated plan, which articulates the feedback that Ana shared, as well as anything to make sure that practitioners have a good guide document for what one should look like and what one should cover. So I would be pleased to take that away and work with legal colleagues within Cambridgeshire as well to make sure that it represents the feedback that's provided, obviously of a completely fictitious child, in order to set a good example. It may be a good exercise between Cambridgeshire and Peterborough together actually as well.
Yes, a fictitious child is a good point. So one that's, as you say, made up but ideal, rather than one which is ideal but confidential, which is what I was thinking about. Thank you, Steve. I don't think there is any other questions. We can hold fire for a moment, but otherwise, that would then conclude our webinar. There is a further question. Oh, I don't know who best to direct this to. As a family magistrate in Cambridge and Peterborough, why are the systems different? I don't know if that refers back to Steve's talk, perhaps, in terms of how the two authorities work, I think, slightly differently. I don't know if you can assist with that, Steve, in terms of the slightly different approach for Cambridgeshire and Peterborough.
I'm not able to refer back to the applications to the court for hearing, having not worked within Peterborough and having joined Cambridgeshire following the separation of the two authorities. I think our approach to supporting special guardians and how we bring our information in assessments together probably is relatively similar, is designed to be relatively similar, utilising very similar documents in order to articulate our information. The key differences, I think, within Peterborough and Cambridgeshire are in some ways about how we represent the information available to special guardians and where we are at with our consultation with special guardians.
Thank you, Steve. Ana has her hand up. Can I move to Ana for that next?
Yeah, well, I was going to say, I mean, I obviously deal with them from both local authorities regularly, and I think any differences are really just in layout and the way they're put together, because they both have the same requirements and list the various things that are needed. So I think it's probably just different authorities have different layouts. I don't think it's the content or compliance with the rules that's a problem.
Thank you, Judge. I'm grateful. I'm just going to check the questions once more. No further questions. I think we have covered those. As usual, the presentations and the video of the webinar will be placed upon the Fenners Chambers website. It's normally found in the news section. So if anyone attending wishes to refresh their memory, it will hopefully be on the Fenners website soon. I don't think there are any further questions. And therefore, it just leaves me to thank once more all of our speakers for their time in preparing their presentations and also for their time this evening. And I hope it has been informative for all those that have attended. So thank you, everybody. And I hope to see you all again at the next Local Family Justice Board webinar. So have a good evening. Thank you, everybody.